clerk will open the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
We're ready to hear argument in cause number PD-0790-20. Roberto, oh, sorry, wrong one. We're ready to hear argument in PD-0936-20. Jerel, Chinedu, Igboji versus the state of Texas.
Good morning. My name is John Messinger. I'm an assistant state prosecuting attorney. This is an exigent circumstances case out of Fort Bend County. This is a pretty straightforward case if you follow the Supreme Court case of Kentucky v. King. King tells us that a lot of times you're going to have an exigent circumstance that arises as a direct result of police conduct, or in this case, lack of police conduct. And King tells us that that's okay as long as what the police did doesn't violate or threaten to violate the Fourth Amendment. And if you look at what Detective Ramirez did in this case, that's a perfect example of that. He continued his investigation and did not infringe upon appellant's property, privacy, or personal freedom rights until he had probable cause that he was involved in the aggravated robbery, felt confident that there was evidence that might be destroyed if he didn't act. And even at that point—
Counsel, is there a different standard? Like the dissenting opinion in this case seems to suggest that there might be a different standard for exigency for seizure and maintaining the status quo versus an actual search. Is there?
I don't know that the standard shouldn't be different. What you have to do is when you measure the totality, look at the scope of the intrusion to figure out if the action was reasonable. So maybe I've just contradicted myself, but in this situation, you can go back to Illinois versus MacArthur. And you contrast that with this court's case in Turbiati. If it's the home situation, it would be reasonable to say, sir, we have probable cause you have contraband in your house. You're going to step out with us and you can't go in your house without us accompanying you. And we're going to quickly get a warrant. Versus Turbiati, which is, we think you have something in your house. We're just going to go in, sweep it and search it without getting a warrant. And you can see the scope of the police intrusion is what makes the difference between those two cases. And in this case, Detective Ramirez did, I think, everything you could ask him to do. When he had probable cause, he could have arrested, but he didn't. He seized the phone. He could have tried to make some sort of exigency, I need to search the phone now, but he didn't. He went and he got a warrant. And even though he could have done an arrest at any point, he didn't wait until he talked to the suspect, seized the phone, got a warrant, looked at what was on his phone, and then arrested him a month after the offense. So he did everything.
What facts created the exigency then? What was it that was different about why he had to get to the phone and maintain it at that moment versus what he could have done 5 days before?
There are two different aspects of that. One has to do with what piece of evidence you're trying to get at. And the other one has to do with how you view the defendant in all of this. And I think that's part of the confusion the Court of Appeals had. They're making it seem as though, well, if you wanted those videos, you knew about them 4 days earlier, which is true. Right. And so if all you want to do is say, I have probable cause that somebody's phone has these videos, you can do that. But what King tells you is that a reasonable officer can also say, well, yeah, maybe I've got probable cause, or maybe I don't. Maybe 4 days earlier, just based on everybody's suspicion of appellant and the circumstances around the offense, he could have made out a case for probable cause and either gotten his phone or just straight up arrested him the day after. Maybe, and maybe that would have held up. But what King says is there is absolutely nothing wrong with investigating more, hedging your bets, making sure your probable cause is greater. And I think one of the things the Court of Appeals missed here is that while the interest in the phone starts with some Snapchat videos, the evidence that comes in is something you would not have gotten if you had just said, I want a warrant to look at video and pictures. It's the text messages that were damning. And the text messages you get probable cause for when you believe he's a suspect. And Detective Ramirez, and to bring it back around to end the answer to your question, Judge Newell, Detective Ramirez was treating appellant like a victim and a witness until it became clear that appellant did not care that evidence was destroyed or being destroyed and stopped being cooperative. And that's the point at which it appears Ramirez made a judgment call and said, I could have suspected you earlier. I wanted to hear your side of the story. Now I am convinced. And now I am going to proceed and get a probable cause warrant, not just for Snapchat videos, but I'm going to dump your phone because I think you're involved. And you can see how his affidavit reflects that.
So why is it that, so it's the fact that he becomes uncooperative? Why is he required to cooperate if
You're
it's
not
not
required-
an arrest situation?
You're not required to cooperate. And if you go back to this court's case in Wade, the fact that somebody doesn't want to grant consent to the police on its own is not enough for a stop. It's not enough for an arrest, but it's not nothing. It is a piece of information. And in this case, you have two competing stories. You have a manager who says, he's lazy. I didn't give him permission to go out. And we never opened that door after 10 o'clock. And you have the defendant saying, no, she just doesn't want to get in trouble. We open that door all the time. I asked her for permission and she said yes. So I don't want to be in a position, I don't think the court wants to be in a position to say Ramirez should have disbelieved the guy who was on parole and believed the manager. He's under no obligation to do that. So he waits to see what are the responses, what are appellant's responses to the question. Does it make sense with everything else that he knows? And he's been cooperative. You would think that he would say, sure, take an hour, take the Snapchat videos, find what you can. I'm completely innocent. But he doesn't. So again, that's enough to change his mind and make him act on the probable cause that perhaps existed beforehand. It just doesn't matter that it existed before.
But then that gets back to my original question. So that's the only thing that creates some exigency, is that fact that he's no longer cooperating, as opposed to, you've made a great argument why that can be something that can establish probable cause. But what facts do we have that indicate there's an exigency?
Well, the exigency is the officer believed that there was video on his phone, and the testimony about technologically what may or may not have been going on. So the Snapchat's a little bit of a red herring in this case, because nobody has to believe that the only evidence he had on his phone was based in Snapchat. Even no one had to believe that the only video evidence was tied to Snapchat. So the fact, and the Court of Appeals goes through this, that, well, at no point do we show that Ramirez understood what the Snapchat settings were. Well, I think that's the point. You know, if you have something that is possibly deleting or not possibly deleting, then it's a non-factor. It's no different than having a laptop. So I think that aspect should be put to the side. But the fact is, and I think, again, you go back to the affidavit, it becomes a more traditional investigation at that point. We're interested in the videos. The videos may show information. There's some video that Detective Ramirez saw the morning after of him in the parking lot. Maybe you incidentally get the car. Maybe you get a license plate. So there's that aspect of it, even if appellant was an innocent victim in all of this. But you also get everything the officer explains is part of these investigations, which is, now that I'm on board with everybody else who suspected him, cell phones have text messages, they've got communications between him and his Confederates. I suspect him, he knows I suspect him. I'm not letting him walk out with that cell phone. So that's the exigency, that now you're somebody who understands they're under investigation. And you've already told me things are deleting. I don't believe you, because I don't believe your story about your involvement in the offense. So there's no reason for an officer to let that evidence walk out the door. And again, as in MacArthur v. Illinois, all he did was seize the phone. He didn't arrest him, even though he could. He did the most limited thing he could to protect the evidence that's on that phone.
Well, counsel, isn't there a danger that if we adopt, your side of this argument, that basically no officer is ever going to get a warrant for a phone? Like, they're just going to bring somebody in, and then the minute the person says, well, I don't consent, the officer says, well, then I'm not letting you walk out of here without your phone, so give me your phone. I mean, isn't that a danger here?
There's always a danger that the longer you wait, that the evidence could be lost. And that's a risk that's going to be borne by an officer who wants to make a conscious decision. I mean, to paint the officer, and I know you're not saying this, but the idea is that there are officers who just don't want to do paperwork, and they're going to take their chances on this. Let's ask them and then wait for a change in consent and then take stuff without a warrant. But at some point, the officer is going to find out that they're not charming enough to get enough consents, and they're going to wait too long, and the evidence is going to be gone. So really what this is, it's an investigative technique judgment call. And it's something the Supreme Court has said we shouldn't be involved in, and it's something that we're ill-suited to do. And
Well,
the tech expert for the state. Yes,
Mr.
sir.
Messenger, it's more than a technique. He's actually seizing an individual's property and depriving him of access to that property.
No, just to be clear, the technique is not seizing thing. It's not, that was not meant to say, hey, let's roll the dice and then we can always seize it if we want to. What I meant is the technique of not seizing things at the earliest opportunity, of treating somebody like they might be innocent, of doing more investigation. The tech expert for the state explained that, look, the longer you wait, things that got deleted are getting overwritten. So if you're an officer who's trying to play this game, you are going to get burned. And at some point, you're going to decide, I'm not going to do that. But there's no way for this court or any court to say, I think that's what this officer was doing. So as a matter of policy, we're going to tell you, you have to seize things at the earliest opportunity. And to your point, Judge Richardson, we're saying, yes, he got his phone taken away. But the answer, if this officer didn't do the right thing by waiting until he was really sure he needed to take it, then the answer to that is, when you have probable cause, take it earlier. Take the phone earlier, arrest him earlier, seize it pursuant to his arrest.
Let's just take it to the logical extent. Does that apply to a laptop, and then does it apply to a home computer, if that's their concern?
No, and I understand the complaint there, but much like cell phones have become a shiny object that I think has gotten maybe undue attention, the fact is cell phones are used sometimes as phones. And so the primary thing that the officer wanted in this case, he didn't say, I want laptops and I want his home computer and I want all of his cameras. He said, look, this guy was the inside man. They communicate with people. I just, let's get a look at it. And big shock, the deleted texts that were recovered show that he communicated with Confederates. And just in terms of technique and investigative strategy, there were two other people involved, the ones who were holding the guns. So this officer was treating Igboji like he was possibly a victim witness.
How's that any different than a laptop that the guy has in his car?
Well, the detective determined and made sure he put in his affidavit that Igboji had his phone on him at KFC. If there had been evidence that Igboji had been on his laptop while not working at KFC, he would have said, look, I think he sent emails or some sort of messages versus laptop, and I want to dump that. So again, we have something that's tailored to the investigation.
Could this information have been obtained anywhere else?
The information that was offered at trial could not have been obtained anywhere else because we never found out during trial who the other suspects were. They're text messages.
Okay.
I mean, I guess we could have just gone to the phone company to do it, but then he has standing to complain about. So, I mean, it's the same place. We have probable cause. And this is something that's weird I'm kind of stuck between the Court of Appeals, who appears to be saying they don't talk about probable cause, but it underlies everything. I mean, unless they're only talking about the Snapchat and not focusing on the evidence submitted at trial, the implicit assumption is there was all types of probable cause the morning after to do whatever was eventually done.
Mr. Messenger?
Yes.
You describe the phone as a shiny object that's getting undue attention, essentially. But I mean, these days people describe their phone as their life. I mean, they have everything on their phone. They rely on their phone for everything. And so these smartphones are more than just a phone. And as Judge Richardson talked about with the laptop, I think they're even more than a laptop. So it seems like almost seizing a phone is almost like seizing a home at this point.
We can seize homes.
I understand.
We've been seizing homes since 2001, at least.
I understand that, but under circumstances like this, it seems to perhaps be a stretch.
If he had probable cause to arrest him, which I've not heard anybody say he didn't, then he could have arrested him and then seized it pursuant to the arrest and then waited to get a warrant. Instead, he didn't arrest him, let him walk out the door. He was free for another month and the officer still got a warrant.
Well, wait a second. How could he have arrested him? Like, is this a plain view arrest, or would he even needed a warrant to arrest the guy
I mean,
too?
constitutionally speaking, not
Okay.
not under Texas statute, but the same probable cause that if he had probable cause to get a seizure warrant for the phone, he had probable cause to seize his person and put him in a cell and make him post bond. And the officer didn't do that. The same
Yeah.
way the officer in MacArthur said, and the Supreme Court said it's reasonable, we're just not going to let you go where you can destroy things. It's your home. It is at the pinnacle of Fourth Amendment jurisprudence. But you can't
Is
go
there a
in-
difference? I'm sorry, counsel. Is there a difference? I know you're about to run out of time, so I wanted to ask this question. Is there a difference between what happened in Kentucky versus King and what happened here? In other words, the issue in Kentucky versus King was the police knocked, and the question is, well, by knocking, you created the exigency, but the exigent circumstances that they demonstrated was sounds inside the apartment that indicated there was stuff being destroyed. Here, the guy has simply said, "I'm not cooperating." Does that by itself create some sort of exigency? Is that what Kentucky versus King says?
It's not a clean analogy. You're talking about split second action, but in the
Right.
split second, the thing that changes it, I mean, we keep coming back to his lack of consent and sudden change in cooperation. But the reason that's relevant is because of everything that came before it. So he's a suspect. There was probable cause. If the change in consent is nothing and the arrest or search warrant could have been pursued prior, then what that is the factor that says this officer wasn't unreasonable in not arresting him earlier. And this officer can now see that somebody is not being cooperative, is saying things are deleted that may or may not be deleted because this officer believes he lied about what happened at KFC. So that's what it is. Now, I know what I know, and I'm not letting you walk out with the phone because there's a reasonable probability you're going to delete stuff that's going to be relevant. And that's
So he lied. It's that he lied. It's the police officer believed that he lied to him.
that is the last thing. And then going to the affirmative conduct that the Court of Appeals glommed onto, we don't have to let him start fumbling with the phone to then snatch it from him. We just do not have to do that. That's the lesson of MacArthur v. Illinois.
Counsel, did you want to save some of your time for rebuttal?
Yes, Your Honor. Thank you.
Okay, thank you.
May it please the court. Can everyone hear me?
Yes,
Good.
you may proceed.
Thank you, Your Honor.
Don't look like a kitten.
This is why I have a flip phone. But let me start with this bit of time. 5 days. 5 days does not exigent circumstances make. This robbery occurred in the evening on December 10th. The officer interviewed these folks, interviewed the appellant on the 14th and took the phone. And then 2 days later, on the 16th, got a warrant. The idea that there were exigent circumstances in this is a fiction.
But counsel, what's wrong with the police just maintaining the status quo? I mean, what's wrong with they talk to the dude and they think he's going to be uncooperative? Why can't they just say, hey, everyone, let's cool out. Let's keep the phone safe so that no one does anything. I've got probable cause. Why can't we just say that the police can maintain the status quo?
It starts from the premise that he had probable cause. He did not. The only thing that he saw, the officer, was a video from someone else's phone, another employee, showing what appeared to be the appellant videotaping the investigating officers who responded that night, the patrol cars. I think in modern society, that's the most normal reflex that people have, is filming an incident in their lives, just as people have filmed police brutality or riots or significant events of their family. This young man had video, supposedly, that he had sent out to the other employee of the officers arriving at the scene. That establishes nothing at all. And for the detective to come back and somehow insist that this makes him suspicious That's awfully weak, Your Honor. And the detective could not have arrested the appellant on that day when he sees the phone. Now, if you are going to make this an investigative detention, if immediately upon seizing the phone, the officer had gotten on the phone and gotten a warrant to search the phone and done so within, a few hours, we would have a different discussion.
I have a question for Mr. McCann.
Yes, sir.
So it might be two-part, but it begins with, are search and seizure the same thing? And if they're not the same thing, then what are you complaining about in this case?
They're never the same thing, but what I am complaining about on this is that this man stole a person's property. He seized a phone he had no right to.
Did the taking of the property lead to the discovery of evidence incriminating your client?
Wrong analysis, Judge. That's the flat wrong analysis, and this is why. This is the retroactive justification of unreasonable search and seizure. When the police commit a crime, when they steal things, that goes back to Jones v. United States and Justice Scalia's opinion, they are not entitled to retroactively justify that because they lucked out and got evidence. This is a case, and I'm sorry, but this is a case of an officer doing the exact wrong thing at every step. And what he did to start.
Counselor, you said a few minutes ago that he could have talked to your client and gotten a warrant, which would have taken a couple hours. Well, are you saying then that then your client could just walk away in those couple hours, and where would the phone be then?
No, I'm not talking about an arrest warrant, Your Honor. I'm talking about a warrant to seize the phone.
I understand.
Okay.
But if you got to wait a couple hours, is your client just going to hang out until the warrant comes around and stand there with his phone?
Well, I'm not sure that's a relevant question, but at the same time, if he's sitting there and not free to leave, then he's under arrest in any case.
But you said he couldn't be arrested.
He could not have, because I dispute completely that anything up to that moment had given the officer probable cause for the warrant, but that's not what we're having here. That was not preserved below. What we are facing is the seizure. Now, we can't go back and inject the argument on probable cause about this because that wasn't preserved. But certainly the seizure is, and that was wrong.
Counsel?
Yes.
Counsel, how free are we to actually revisit the issue of probable cause? I mean, I'm not saying that we're not. I'm just saying, is this a situation where we're simply deciding whether exigency existed, or are we allowed to look at the lower court's opinion and if there was a determination that there was probable cause to justify or not?
Your Honor, you're always free to find other reasons to look at the case, but on the questions that you all granted, we're looking at exigent circumstances. I think following one's own procedures in this, and appellate rules of preservation, that what you're left with in this is the issue of exigent circumstances, and that never existed here.
Do you have any complaint at all about the search of the phone?
I do, but that's not preserved, Your Honor, and I respectfully don't believe that that's an appropriate topic for today, only because the issues before you are the exigent circumstances. If I could have a bit of time to answer that, I will.
Let's suppose that we agree with you, just hypothetically, that we agree that the officer shouldn't have taken the phone when he did. How does that lead to the officer coming into possession of evidence that is incriminating to your client?
Well, at that point, if the officer is looking at other investigative matters, he does have the witnesses to re-interview. He also has the phone company to get texts from, and he can subpoena that or request it. He has consent of the young woman that he apparently interviewed before the 14th at the restaurant, who was in receipt of the video posting from the appellant. If she would consent to perhaps let her phone be looked at, that may have led to others. So I think if I get what you're asking, were there other means available to the officer? And yes, there were.
That's not what I'm asking at all.
Okay.
The way I'm seeing it, Mr. McCann, there's two things going on here. First, the officer took the phone, and you call that a theft. You suggest that the officer stole the guy's phone. Well, if that's all he did, if all he did was steal the phone, then he doesn't have any new evidence from that phone that he could use to go to trial against your client and result in your client's potential conviction. What led, it seems to me, to the discovery of that evidence was a search of the phone. And you can correct me if I'm wrong about this. I believe from what I've seen in this case that took place after the officer went and got a warrant. And I don't know that the officer used anything about the context of his, in your view, having stolen the phone to enhance his probable cause to search the phone. So anyway, those are my thoughts. And I would love to be illuminated more from you to see why maybe I might be seeing that the wrong way.
Let me put it in this way and see if this helps. If the officer had put in to the affidavit additional information that could have justified either the search or the seizure, then perhaps we'd be having a different conversation. I think that based on the affidavit that was in there, I would suggest that had that been preserved, we would be contesting the probable cause within the four corners of the affidavit at this time. Reluctantly, we're not. And if the court wishes, I can certainly file supplemental briefing on the issue of whether this court wants to revisit probable cause. I think that given the narrow constraints that you've accepted the PDR on, that may not be the most judicious use of your time, but I'm happy to do that if the court wishes.
Mr. McCann.
Yes, sir.
I'm just curious from a technology standpoint. Had he deleted that information, had the officer not taken the phone from him at that time, would that information still have been available through the server or the phone company, or once a text message is deleted, is it gone?
The answer to that is, sadly, it depends on the policy of the phone company. For instance, T-Mobile, and this is extra record, obviously, but from personal anecdotal experience, I can tell the court that, to my knowledge, T-Mobile does not keep records of the texts beyond 90 days. So if you're trying to retrieve old texts in order perhaps to settle an argument about the Astros or the Texans.
Well, I'm thinking of within a very short time frame, from the time of the crime until the time that an officer has the opportunity to get information from the company. Was it ever raised in court that the officer said, look, if I didn't get the phone at that point, it would have never been available, either through the server or from the cell phone itself?
Well, I believe the officer admitted that he had a misunderstanding of how Snapchat works, which is that while there is a function that allows those to be deleted from the public posting and from one's private account, the servers, as far as I understand, are always available to subpoena or to send. So if we're asking, was the officer's misunderstanding a good faith misunderstanding, I would agree that that's possible. But nevertheless, it's an incorrect understanding. And I think that a lot of folks that are in different media, such as Facebook, would not be in a position to ever worry about automatic deletion. And that means that those messages or IMs are almost always available by other means than taking the phone. If that answers your question, sir.
It does. Yeah, thanks.
If I may go, oh, yes, ma'am.
Ask, what did the Court of Appeals say about probable cause to seize the phone? And if they did find no probable cause, then why did they go to exigent circumstances?
Well, as I read the opinion, Your Honor, they found that that issue was not preserved, which is why I'm not trying to avoid your question, Judge Yuri. I'm just saying that I don't believe it's properly before us. They looked at this and said, look, we've got enough on our plate. You didn't preserve this, but we can go to the seizure of the phone and decide whether that fits in. That is preserved. And in that case, they looked at it and said that it was improper. And they went, in my opinion, when you look at this, they went through every step that they could to give the officer the benefit of the doubt, even considering the consent issue, despite the officer's testimony that he was seizing that with or without the young man's consent. So it appears it's just not properly before us, Your Honor. And again, I can brief that if the court wishes.
If I could just clarify, you're saying that probable cause warrant is not before us. Is that right?
That's correct, Your Honor.
But what about probable cause to seize the phone? Did they adjudicate that or just assume it or what?
I don't believe they adjudicated it all. I think they looked at it as a warrantless and then went down the list of warrantless exceptions and were left with exigent circumstances because consent was, frankly, disavowed by the officer.
But so did they therefore find that there was probable cause for the seizure? That's my question.
I would say no, Your Honor, because if they had thought that existed, they would have acknowledged it in their analysis. So I would say the implicit finding is absolutely not. If the court,
sorry.
Yes, Your Honor.
No, finish the question. Finish the question.
I would say absolutely not. And the testimony and the questions as I read them did not really explore that. Honestly, I'm not even sure you could get that from the record because of the way the questioning went.
Does the finding of exigency, does an exigent circumstances analysis assume the existence of probable cause, or does it not? I mean, that
it does not, Your Honor, because the step is, as the court well knows, is to find a warrant. If there is no warrant, then one goes down the exceptions: border search, administrative, health and welfare, exigent circumstances. And when one finds a circumstance that fits, then one does the analysis there, or consent. And in this case, they found no consent, but looking at exigent circumstances, they found no exigent circumstances whatsoever.
If police can then, I guess this is another sort of bring this together too, is if the police then can rely on a subsequent search warrant, regardless of whether exigency exists or not, wouldn't that open the door, or would that open the door to police officers essentially just seizing things and waiting until probable cause develops for a search warrant?
I would say yes, Your Honor, and this is why this case is so critical and so important. Judge Slaughter's point about the phone being, frankly, a record of our lives that is carried around with us, other than myself, who still relies on a flip phone. This is a case where if you take the phone, you take banking records, you take medical health records, you take passwords to every account a person has, email private correspondence, or that they believe is private. You take far more. In fact, you can actually control one's car from the phone now, depending on how recent a model you buy. So to take that is to take a person's life in hand, quite literally, and prevent them from doing all the things that they wish to do through that small handheld portal. And I look at this as a dangerous, dangerous extension of power to the police, because when they take something, and I still stand by the fact that he essentially stole it. When you take something from someone, that is not reasonable. It's never been reasonable in the long history of our country if you sit there and take it without more than what this officer had.
Well, let's say that what happened is that the officer illegally arrested your client and put your client in jail and held him there for a week. And in the meantime, they discovered evidence linking your client to a serious crime. Would the evidence that they discovered while they had your client illegally arrested need to be suppressed?
And in a case of a fruit of a poisonous tree analysis, Your Honor, it would depend on how attenuated it was from the arrest. For instance, if they found it in a search of his property pursuant to arrest and a seizure of that stuff, if the rest was illegal, then yes, it gets suppressed. If it was developed by another source, and this does relate back to this case, if the officer got it from somewhere else, then probably not, and that could go forward. But when you look at a fruit of the poisonous tree doctrine, the seizure of the phone is the critical incident here. It is beyond the scope of the police powers, and it led to, luckily for the officer, it led to deleted texts that were incriminating, but that's not the analysis. We can't go back and justify it because, well, they found the dope. That's not how we do it. And unreasonable searches and seizures, this is the definition of unreasonable search and seizure, when someone takes a phone from my hand without a warrant, without my consent, and then holds it for 2 days while they meander to a judge to get a warrant signed. So when one looks at this, I sympathize with the analogy of the laptop, Judge Richardson, and Judge McClure, I think the danger here is very clear. This extends police abilities to simply take things at their will. And with due respect to my colleague, Mr. Messenger, that is not a less intrusive path. That is a much greater intrusion into our daily lives at the police will. And that is not what our Constitution wants to protect us from. I wanted to address one more point in this, and looking at it from the standpoint of the court's ability to make and decide policy, I would respectfully suggest that perhaps this case does not really raise the questions that I believe the state's prosecuting office wanted to address, at least on these facts. I believe these facts are much different on the ground than my colleague, and I genuinely think that a better case for the questions that were proposed may be forthcoming. If the court decides to go forward and address this, I would respectfully ask that if it wishes, we can submit supplemental briefings on the issue of probable cause, vice the issue of exigent circumstance. I believe that I'm correct in going forward in saying that the implicit finding has to be that there was no probable cause, because the Court of Appeals would have stopped there. And this record is probably not as developed as it would want to be for that type of analysis. But I leave that to the court, and I will await direction from you all. That being said, I yield my remaining time, and thank you for the opportunity to argue today.
Thank you, counsel.
May it please the court. If I could just have a quick minute, I think I can address all the court's questions on probable cause and the scope of availability of this evidence. The Court of Appeals opinion isn't really helpful on this point, because Judge Keel's right. If this were an easy call that there was no probable cause, you wouldn't waste time with an exigent circumstances analysis. So that's why I'm proceeding under the assumption, and I should add that they did not say we're going to assume for the sake of argument there's probable cause and pour the state out on exigent circumstances. So I'm assuming that it's obvious, and that opposing counsel is the only person who doesn't think that there was probable cause that appellant was involved in this. I thought it's not a problem from my point of view, but the more interesting aspect is that most of the probable cause existed, and probably a warrant would have issued before Ramirez sat down with him. What the Court of Appeals is doing wrong, though, is I think their analysis focuses on when you knew that there was maybe a Snapchat image, and that was the morning after, 3 days before this conversation. But that's not what was introduced, and that may not, certainly isn't what another reasonable officer would have been after, and not what Ramirez was after when he had his Kaiser Soze moment and said, okay, you are now my suspect. I've just realized something. I've treated you like a witness, and I've just realized something. Once that happens, this is no longer a question of whether or not there were exigent circumstances to get these Snapchat videos we all knew about. Now it's about exigent circumstances for the unknown unknowns. You can guess, yes.
Like, I guess this is maybe a two-part question, but does exigency have to be based upon the existence of probable cause for a warrantless search? Or are we, if we're to address the issue, are we just to say, we assume that there's probable cause because the Court of Appeals just seems to have just assumed that?
Well, I mean, you have to have, exigent circumstances is a warrant exception. It's not a probable cause exception. And it makes no sense in the absence of probable cause. It
Okay.
would have been nicer if the Court of Appeals had said something one way or the other. But again, I mean, if you'd like to, you can ask them to correct that and remand it back. But I mean, they spent a lot of time on an exigent circumstances analysis and trod some new ground when PC would have been that easy. And also, I don't think there's any argument over PC. I don't know what else you're supposed to do. Ramirez was nice enough to talk to him to get his side of the story, but he's clearly the inside guy, at least for probable cause. I don't know that any magistrate would have refused that.
Well,
But
I mean,
again,
yeah, like Ramirez basically said to the guy, you can either give me you can give me your phone, or I can go get a warrant and get it. So,
yeah,
I mean,
like
he believed at the time he had the probable cause.
I've talked to all of your coworkers. I've looked at the situation. All the arrows point to you. I hear what you're saying, and I can give you your phone back in an hour, or I can go get a warrant, and I can't tell you how long it's going to take. I mean, it's a pretty standard conversation. But because it goes, at least for this officer's point of view, from a maybe you're innocent to a I don't think you're innocent, well, now you have a new set of circumstances. Now you have a suspect who we can't let walk out with the phone. And the phone is important, but it's not more important than anything else that we can get a warrant for. The answer for your property and privacy rights is always the same. Kick down your door, get a warrant. Stick a needle in you, get a warrant. Pump your stomach, get a warrant. Cell phones don't deserve anything higher. And so all we did was temporarily.
Because I think you're kind of raising something that Judge Slaughter raised, which is, I feel like the phone is more important because it is your life on there. And if you take my phone away for 3 hours, that's more intrusive than if you just get a search warrant from Google and Facebook and Snapchat and my cell phone provider to get my text, because at least I still get to keep my phone.
The Supreme Court has made it clear that the Fourth Amendment is not a least restrictive means test. The warrant fixes everything. There's no super warrant. There's no special warrant for special circumstances. If we can keep you out of your house without a warrant and search and rummage your house with a warrant, we can hold on to your phone until we ask a magistrate for permission to look into it. There's nothing more.
Can you keep somebody out of their house for 3 or 4 or 5 days?
No, it has to be a reasonable amount of time.
And how long did they have the phone?
To get the warrant 2 days. They executed the warrant within another 2 days. Nobody raised how reasonable that is in the scope of things, so that was never decided below or below. Well, if you've got no other questions.
Counselor, your time is up.
All right, thank you.
Thank you. The case is submitted and the court will stand in recess until 10 o'clock.